Thank you, Madam Chair and members of the committee. Senate Bill 315 creates the Artificial Intelligence Safety Measures Act. At its core, this bill is about protecting against the most catastrophic risks that advanced AI systems can pose to public safety. We are talking about AI systems that are so powerful that they can provide expert-level assistance in creating nuclear, chemical, or biological weapons and engage in conduct that would constitute murder, theft, or extortion if carried out by a person. These are not merely theoretical concerns. For example, according to court documents, a man charged with a mass shooting in Florida last year received material guidance from an AI system that advised him to target children and to increase his death toll. One major AI developer has publicly warned that its most advanced models can already provide meaningful assistance to novice actors seeking to create biological or chemical weapons, with a senior member of its technical staff describing the risk as, quote, very real. A study last year documented how leading AI models successfully provided accurate instructions for recovering a live polio virus from commercially available synthetic DNA. And this past winter, AI systems were used to conduct a cyber attack on a water treatment facility. The catastrophic threats posed by AI are real, and in the absence of congressional action, it is critical for states like Illinois to fill the void and protect the public. This bill does several important things. First, beginning January 1st, 2028, large frontier developers must write, implement, comply with, and publish on their website documented technical and organizational protocols to manage, assess, and mitigate catastrophic risks from their models. Before deploying any new or substantially modified model, they must also publish a transparency report disclosing the model's intended uses, any restrictions on those uses, and summaries of their catastrophic risk assessments. Second, large frontier developers must submit to IEMA a summary of any assessment of catastrophic risk resulting from their internal use of the frontier models on a quarterly basis. And third, all frontier developers must report critical safety incidents to IEMA and the Attorney General within 72 hours of them occurring, and if an incident poses an imminent risk of death or serious physical injury, they must also report to an appropriate law enforcement or public safety agency. These provisions closely mirror what is already law in New York and California. Additionally, the bill provides robust guardrails to ensure accountability in the form of strong whistleblower protections for employees who raise safety concerns and independent third-party audits of each developer's compliance. And at the chairwoman's pleasure, I would ask for an opportunity for witnesses from Secure AI Project and Anthropic to also give testimony in support.
Absolutely. Thank you, Representative. I will note we have 14 entities listed as proponents, and I will read through them. Future of Life Institute, Redwood Research, Center for Humane Technology, Moms Against Media Addiction, Office of the Governor, Anthropic, Techni AI, Demystify AI, Secure AI, Encoda AI, Illinois National Organization of Women, and Design It For Us. We have 2 entities who have filed in opposition, TechNet and NetChoice. Who do we have here, and are you wishing to testify? Please introduce yourself for the record.
My name is Scott Wisor, Chairperson Williams, Vice Chair Rita, Spokesperson Spain, and the rest of the members of the committee. Thank you for the opportunity to present today. I'm Policy Director for the Secure AI Project. We are an organization that supports the development of artificial intelligence, but believes the path to enjoying the benefits of innovation is paved by responsible guardrails. We're a nonprofit, and we don't take any corporate or government funding. I'm testifying in support of SB 315. My organization supported similar legislation that was enacted in California and New York, and I can speak to the emerging approach to AI safety across the states. SB 315 is a transparency-focused approach to AI safety. It requires the companies developing the largest and most widely used AI systems to have a safety plan for catastrophic risks, to report major security incidents to the government, to protect whistleblowers, and to require third-party auditors to assess company compliance with their stated safety commitments. This legislation is overwhelmingly supported by voters. In polling from Impact Research, 89% support this legislation, and each of the components of the legislation is polling at 87% or higher. This widespread support crosses party lines. There's almost no deviation across parties in their support for AI safety. The risks which this bill tackles are present today. At least 3 of the leading frontier AI companies have disclosed in their own safety evaluations that their models may provide meaningful uplift to novices seeking to build biological weapons. Multiple cyber attacks have been reported in the last year to have been enabled by advanced AI systems. And a recent AI model, Anthropic's Mythos, is so powerful it cannot yet be released to the public because it's so good at end-to-end cyber attacks. Another model, OpenAI's GPT-5.5 Cyber, is only released to vetted cyber professionals for the same reason. Setting the rules of the road for AI is one of the most important things that this body will pursue this session, and the time to act is now. SB 315 is supported by dozens of organizations, from AI startups to venture capitalists, civil society, youth organizations, and AI verification and auditing firms. OpenAI, the largest company by number of users, and Anthropic, the largest company by enterprise revenue, are both proponents on this bill. We encourage you to vote yes, and I'm happy to answer any questions.
Okay, thank you. Mr. Hartmann.
Chair Williams, Spokesperson Hammond, honorable members of the House Executive Committee and esteemed staff. My name is James Hartmann. I am the Midwest Public Policy Lead for Anthropic, and I am here today to support the passage of SB 315. As I mentioned at the AI subject matter hearing a few weeks ago, Anthropic supports legislation that requires AI labs at the frontier to create and abide by safeguards in order to protect Americans from harms that could arise from their models. While Anthropic follows this approach, a safety framework and disclosure requirement backed by law, audits, and whistleblower protections turn today's best practices into tomorrow's floor. And as AI at the frontier becomes more powerful, it is increasingly clear that these disclosures need independent verification. And Representative Didech's bill does just that. It establishes an architecture for compliance audits, annual third-party review of the largest frontier developers' compliance with the law by independent auditor teams, auditors that already exist. In the interest of time, I'll stop there, but we want to thank Representative Didech for bringing forward this important measure. Thank you.
Thank you, and I will note we have Senator Edley Allen in the House, who is the Senate sponsor of this important initiative. Thank you both for working on this item. Anyone else seeking to testify? Okay, Mr. Anderson.
Good morning, members of the committee. Taylor Anderson on behalf of TechNet, Technology Trade Association. I'll keep my remarks very brief. TechNet is not opposed to what the bill is attempting to do. We have some concerns with the manner in which it seeks to do it. You've heard guardrails mentioned quite a few times by the previous speakers, and our concern is that right now this bill does not have any guardrails around what that auditing, third-party auditing looks like. We have real hesitancy because this deviates from bills that were passed in California and New York that do not have third-party auditing. This would be the first in the nation, and we think more time and consideration needs to be put into what those third-party auditors do, the processes that they go through, the requirements that they might have to have, and who's able to actually qualify to be a third-party auditor. At the start of this committee, we heard on another bill about how handing responsibilities over to third parties sometimes can lead to some unintended consequences. And so just like in the cannabis space with security, we feel that without the appropriate guardrails here, we could face kind of similar hamstrings. We'd like to see perhaps a task force put together to look and discuss and put in place rules around the third-party auditors and what they're actually supposed to be looking at and how they're supposed to be carrying out those responsibilities, put more clear guidelines into statute with regards to some of the national security concerns that potentially third-party auditors could expose, and any outside liability. So again, I just wanted to briefly explain our concerns. We're not opposed to what the sponsors attempt to do. We just have some concerns with and think there needs to be more clarity. Thank you.
Thank you. And I do believe we have a few witnesses who are wishing to testify via Zoom. Megan Stokes, are you online?
Good morning, Chair Williams and members of the committee. Thank you for the opportunity to testify today. My name is Megan Stokes. I'm the State Policy Director for the Computer and Communications Industry Association, or CCIA. As my colleague from TechNet mentioned earlier, our issue is not necessarily with the intent of the bill. It is around the concerns around the audit provisions included in Senate Amendment 2. The challenge is that the ecosystem needed to make those external audits credible and consistent simply does not yet exist. Today, there's no widely recognized certification standards, licensing structures, or oversight mechanisms for those AI compliance auditors. So as drafted, the bill would require companies to participate in a process before Illinois has established who is qualified to conduct those audits, which standards would apply, or how consistency and accountability would be ensured. As mentioned on an earlier discussion on a different bill, it was sort of we have to pass it to see how this works. Well, this is not necessarily what you'd want to do here. We do believe that Illinois should take a more measured approach, similar to recent efforts in Virginia. Virginia passed a law, Senate Bill 384, that directed agencies to study the feasibility of independent AI verification systems, to evaluate the risks, the available standards, measurable metrics, oversight needs, and whether qualified auditors are available before imposing these mandates. Before requiring the audits, it would be important to look at answering a couple key questions. Do qualified auditors exist out there? Do they need to be trained up? What standards should govern their work? How will consistency and accountability be ensured? So for those reasons, we respectfully urge the committee to remove or to substantially revise the audit provisions in Senate Bill 315 and instead pursue a more deliberative framework building approach. So thank you for your time and consideration. Welcome any questions.
Thank you, Ms. Stokes. We also have another witness online seeking to testify, Amy Bass. Are you available?
Good morning, Chair, members of the committee. My name is Amy Boss. I'm the Vice President of Government Affairs at NetChoice, a trade association dedicated to internet free enterprise and free expression. We support thoughtful AI governance. We believe in accountability and consumer protection, but we must respectfully urge you to oppose Senate Bill 315 or at a minimum remove its audit provisions. My colleagues at CCIA and TechNet expressed concerns with the audit provisions, and I must agree with them on that front. The bill mandates that large AI developers conduct these annual third-party audits of safety compliance. The infrastructure, again, to conduct these audits does not exist, and the bill creates no pathway to build it. There are no certified auditors with the technical expertise required. There are no established methodologies for these audits, what these audits should measure. The bill essentially requires companies to hire auditors who don't exist. So making matters worse, I think we do still have some concerns that some of the core standards are vague. It requires meaningful human oversight, but doesn't define exactly what that means. We are concerned just with creating a chilling effect on frontier AI development. Every dollar spent on undefined compliance requirements is a dollar not spent on innovation and safety research. So we do oppose the committee, or we do urge the committee to oppose this bill, or again, to remove the audit provisions. We would also support commissioning an independent study to assess whether the necessary auditing infrastructure, standards, and qualified evaluators can realistically be established before any requirement takes effect. Thank you again for the opportunity to testify, and I'd be happy to answer any questions.
Thank you. Do we have anyone else seeking to testify this morning? Okay, we'll turn to questions from committee members. Leader Morgan.
Thank you, Madam Chair. Representative Didech, thank you for bringing this morning. I appreciate the discussion of what's in the bill, in particular looking at ways in which we could even improve upon what states like New York or California have produced and passed. I was surprised a little bit about some of the discussion about the third-party audit provisions. as I'm a little surprised that there would be such a concern about an independent verification, independent audit. Can you tell us a little bit more about some of the guardrails that are in the bill about audits?
Yeah, thank you. Yes, and I'll answer that question. But first, I do want to note for the record, this is a little bit of an unusual hearing. This is the first time that not one but two individuals have testified against one of my bill, neither of whom I've ever met before or have ever even attempted to introduce themselves or express their concerns. So the individuals appearing on Zoom, you know, they may be AI people for all we know. I don't know, but I've never met them. I wish they would have reached out to explain to me their concerns. I would have been happy to talk to them. To Leader Morgan's question, this bill has some of the most robust guardrails of any legislation that's been introduced across the country regarding the third-party audits. The language in this bill is the product of a series of really productive conversations that occurred between Democrats and Republicans in the General Assembly. I want to walk through them, and these were core to, I think, the reason why this bill earned widespread bipartisan support in the Senate. First, the bill itself requires that the third-party auditors must be consistent with generally accepted auditing standards and best practices and shall possess demonstrated competence to perform the audit. Additionally, they must include experience employing or contracting with individuals who possess technical expertise in the safety of frontier models. There's also the strongest ethics language of any of these bills that's ever been produced across the country. A large frontier developer shall not retain a third party if either the large frontier developer or the third party has a financial interest in the other party. Additionally, the strongest safeguards of any bill on the subject in the country to protect the companies themselves that are subject to the audit, to protect the frontier developers' trade secrets and confidential business information, cybersecurity, national security of the United States, or public safety. A large frontier developer may impose security protocols on the third party, including but not limited to restrictions on note-taking, copying, retaining, or removing materials, requirements for on-premise review, and confidentiality requirements. These are substantial protections that can be exercised not even subject to an agreement, but at the sole discretion of the companies that are engaging in the third-party audit. I'm very comfortable and very confident that the concerns that are being raised are addressed within the text of the bill. And I think Scott from Secure AI has something to add as well.
Thank you. I wanted to speak to the existing ecosystem for third-party verification. Multiple previous speakers said no such ecosystem exists, and that's false. On the supporter letter, which has been signed for this legislation, there are a number of organizations that do the work which would be involved in auditing and verification. It's signed by Redwood Research, Poseidon Research, Apart Research, Babel AI, and the AI Verification and Evaluation Research Institute. So to understand the ecosystem for firms who can do this work, there's kind of two categories. One is boutique specialist firms where all they do is work on AI verification and evaluation. The other is the traditional auditors, your Deloittes and KPMGs. The Financial Times reported over 12 months ago that the Big Four were moving into AI assurance as a big part of their business. And so it's not the case that these firms do not exist. They exist, are already doing pilots with the largest AI companies. And the fact that two AI companies are endorsing this legislation, both of those companies nearing $1 trillion valuations, both of them heading towards IPOs, they wouldn't sign up for it if they didn't think they could work with credible auditors. And so that ecosystem already exists today, and it's just not the case that those firms aren't present.
Does that wrap up your questions? Leader Hammond.
Thank you, Madam Chair, and thank you, Representative Didech, for this. I'm hearing a lot about the third-party audits and the concerns over that. But there's a lot more in this bill than the third-party audits that hinges on a lot. But this bill requires a lot of oversight and a lot of protections as I'm reading it. So can you address some of that, and then, if you will, part of it includes the emergency management working in concert with the Attorney General, but appears as if, at least by our analysis, the emergency management is opposed. So if you would address that as well. Thank you.
Yeah, so when this bill was heard in the Senate, IEMA expressed opposition to the bill. Since then, there's been a series of conversations, and my understanding now is there's a comfort level with the current text of the bill, and IEMA is no longer opposed. Now, to the things other than the third-party audit that this bill does, I want to emphasize that we modeled this as closely as possible to what New York and California have already done. In a perfect world, we wouldn't be doing this at all. It would be our federal Congress legislating a uniform statewide, nationwide approach. In the absence of leadership on the congressional level, states are stepping up to fill the void to make sure that guardrails are put in place for these frontier AI models. Now, some of the feedback that we've received from the industry, which I very, very strongly agree with and that we've incorporated into this bill, is the desire for nationwide uniformity as much as possible. So the requirement to produce, publish, and comply with a safety plan, the requirement to have the transparency report, the requirement to report critical safety incidents to the state agency, those are all directly mirrored over what's already law in New York and California. So we're not adding additional requirements onto these companies other than what they're already subject to in the other states that have legislated on this issue.
And I'm assuming that that's in an effort to encourage those companies to certainly do business in Illinois, but other states as well, if we can have a uniformity to this.
Yeah, I'm very sympathetic to the argument that it would be a mistake to have a 50-state patchwork where there are different requirements in different states. And in drafting the language of this bill, we've been very, very careful as much as possible to adhere to that and ensure that on the substantive provisions on the bill, we are not veering outside the lines of what New York or California has already done.
Thank you. Leader West with a question.
Thank you, Madam Chair. Can you just elaborate on how this would impact open AI models? I know we're talking about frontier AI companies, but what about those AI models that are not aligned with a company? How would this impact them?
Can I just clarify the question a little bit? The question is about models which aren't from one of the biggest companies? Yeah, it's a great question. So roughly, this is an approach which tries to focus on the biggest developers of AI systems because that's where the risks emerge. So if you build a small AI model that's going to do manage traffic lights or help a student with tutoring, you're not going to be able to launch cyber attacks with that. You have to put in a lot of computation in order to get the capabilities that make you both an excellent coder, but also good at cyber attacks. And so the legislation is drafted so as to identify those developers which have trained models which are very large. And this scoping of companies takes computation measured at 10 to the 26 flops. So that's a measure of 10 and 26 zeros, one digit for each mathematical computation that goes into the model, and has over $500 million in revenue. If you are a company that is building one of these big models, then you are covered as an entity. So the full company is covered. The company needs to submit what their safety plan is going to be. The company needs to report incidents to the government, and the company needs to contract with a third-party auditor to ensure that they've complied with their stated safety plan. And so any of the models from a company will be covered by those safety plans, or they can say, these models that we're working with over here are so small they don't pose any risks. That would be something they state in the safety plan. But they're governed at the company level. And so using that scoping of computation and revenue today, there are something like 5 companies who would be covered. Over time, as the amount of computation going into AI goes up, that number will increase, but it's not a very large number. And the reason is that we want to super focus on those companies that do pose catastrophic risks and make sure that they are acting responsibly. But with a revenue threshold and a computation threshold, we leave the compliance burdens off startups, smaller firms, people who are doing work that doesn't pose risk to the public and does offer the opportunity for innovation.
Thank you. Anyone else seeking recognition from the committee? I will just make a comment here. Representative, I appreciate your point about trying to make it cohesive across other states. I will say, unfortunately, in the tech data privacy space, the federal government has failed to take action in a lot of areas, and so sometimes we're forced to do a state-by-state approach. One example where Illinois has led is, of course, the Biometric Information Protection Act, and we are really fighting to keep that intact here. So here, though I appreciate your efforts to make it cohesive, I have just one kind of question. In light of your funny comment earlier, is there anything in this bill or any other proposal that would require identification when an image is AI generated?
No, that's outside the scope of this bill. I think there's been other bills that address that subject matter in a number of different contexts, but no, there's nothing touching on that in this bill.
We may wish to consider in terms of people testifying whether we require any disclosure just for future reference. Anyone else with questions or comments for witness or sponsor? Okay, seeing no further debate, Representative Rita moves that Senate Bill 315 do pass. Okay, with leave being granted, there are 12 votes in favor, 0 votes opposed, and 0 voting present, and Senate Bill 315 is declared passed and will be favorably reported to the House floor. Thank you.